Understanding the legal elements as a defendant.
What are the elements the person suing you must prove to a judge in order to win against you?
For most breach of contract claims, the plaintiff must convince the judge of 4 important things. These things are referred to as elements.
1. Agreement. 2. Performance.
3. Breach.
4. Damages.
When the plaintiff presents their case to the judge will listen and examine the evidence they present.
The judge will then determine if you have proven the things you said happened did indeed happen.
The plaintiff must prove all 4 elements in order to win their case.
If the judge does not conclude the elements are true, then you will most likely win the case. Therefore, it is important to carefully examine the evidence for each element that the plaintiff has to present. When it is your turn to speak, you can present the evidence showing that the plaintiff cannot prove one or more of the elements. 1. Agreement. Both parties agree to perform their part of the agreement.
An example on how you may dispute this element is you never agreed to repay the loan because the plaintiff said it was a gift.
2. Performance. The plaintiff did their part of the agreement as agreed. Examples on how you may dispute this element. The plaintiff never completed the job you hired them to do. Or the plaintiff only paid you half of what they originally agreed to pay. 3. Breach. You failed to do what you had originally agreed to do. Examples of how you may dispute this element. You made all the payments you agreed to make, even though the plaintiff argues they only received 1 payment. You have a copy of bank statements, canceled checks, or electronic communication showing that payments were made. Or the plaintiff caused a lot of damages to the apartment they rented from you, and you had to use the security deposit to pay for repairs caused by the plaintiff. 4. Damages. Your failure to do what you had agreed caused the plaintiff financial loss. This last one is important because even if you do owe money, you may owe less than what the plaintiff claims. Examples of how you may dispute this element. The plaintiff argues that you owe them interest due to a late payment, but the interest clause was not a part of the original agreement. Or the dispute you have with the plaintiff is 5 years old. It is now outside of the statute of limitation, so the amount owed is no longer enforceable in court. Using Justice Direct, you will go through each of these elements step by step so you can have a better and more complete understanding of what facts you must present for your day in court. Let's get started.